Thanks for consenting to get up so early to attend this first panel of the day. I'm Daniel Métayer. I'm a research director at Inria. Inria is a National Research Institute for Computer Science in France. And I'm very happy to chair this first session with Serge Gutwirth as a moderator. Serge is a professor of human rights and law, comparative law at VUB here in Brussels. So, as you know, consent is just one of the legal grounds for the processing of personal data. But consent has taken more and more importance over the years, and especially here in Europe. And this is reflected in the current version of the data protection regulation. So this emphasis on consent has been criticized by a number of experts. So we thought that it was the right time to have a little debate on this topic at CPDP. So as usual, this panel will gather distinguished experts from different backgrounds, and we'll have different kinds of point of view expressed in the panel. And each speaker will have 10 minutes to make his point, and this will be followed by about 5 minutes of questions, and then hopefully we'll still have 10 minutes for questions at the end of the panel. So for the sake of time, I will stop here and introduce our first speaker. Our first speaker is Christophe Lazaro. Christophe has got a PhD from the European University Institute of Florence. And Christophe is now a postdoc at Inria. So Christophe, the floor is yours.
Thanks, Daniel. Maybe I will use the mic. All right. Do you hear me? All right. So I've been asked a couple of months ago by Daniel to start the discussion with some theoretical foundation or philosophical consideration about consent. But given the limited time we have during this panel, it's a bit of a poison gift or a mission impossible to sum up and present in 10 minutes, 15 minutes, decades of theoretical debates and discussion about such a thorny concept. And all those debates were handled in different fields, so in law, ethics, political sciences. So today I will propose something else than a purely analytical reflection about consent, about the meaning of consent and its characteristics. So basically I won't talk about the genealogy of consent, the ontology of consent. I won't address the question to know whether consent is a mental state or a speech act, a performative. I won't tackle the normativity of consent, what scholars called the moral magic of consent, meaning the idea that consent has a transformative power, that it can legitimize actions that would otherwise count as wrongful or unlawful. And I won't neither tackle the morality of consent and the potential justification of the normative power of consent, such as autonomy, respect for persons, and dignity. I won't do that. What I want to do, is to propose a little exercise, to propose a little thought experiment about consent in the shape of a comparative exercise. My claim is that we could compare consenting to driving a car. So we can draw some interesting theoretical consideration from this comparison. So before elaborating on this comparison, just a few methodological observations. Some, of course, might object that this comparison is not relevant because I'm trying to compare apples and oranges. But this is precisely my ambition. I want to shift the conventional way to look or to apprehend consent via this comparison, and especially I want to take distance from the internalist approaches that consider the activity of consenting as purely mental exercise, as a self-deliberation detached from reality, from external reality, from the context, from the environment. So let's start with this small comparison. I have 3 points. I'll try to be as quick as possible. So first, you don't drive in the air. You don't drive in a vacuum. You drive in an environment made of roads, lights, traffic signs, zones. And it's very interesting to know that when it comes to automobile, urban planning and urban architecture was totally determined and influenced by the proliferation of automobile. So what I want to say is that the space has been segmented in zones. And it's the same with consent. You don't consent in a vacuum. You don't consent in your mind. You consent in an environment. And we should, for instance, think about zones of consent, territories of consent. So this is the first aspect of the environment, the material, physical environment. There is a second aspect to the environment. It's the social or cultural convention. You don't drive the same way in Napoli than in Helsinki. So this is the cultural aspect. You consent differently in one or in another country. There are social conventions also, and this is a very important point. So, how can I say? You consent because others have already consented before you. You consent because others consent at the same time, so they are part of the community. So there is a mimetic side of consent, which is very important to investigate. There is a third aspect of this environmental factor. Those are legal norms. So for instance, we know that because of the proliferation of automobile, the legislator intervened. So to impose a driving license, price and quality of gas, insurance, mandatory insurance, highway codes. So the legal norms are also very important to take into account, and they have been the result of 1 century of negotiation. And what I want to say with this environmental factor is that it's like we still reflect about consent like we reflect about horse-drawn carriage, not about fast cars. So we should really take into account this environment. Second aspect, you don't drive alone. You always drive, I mean, in a city, except in the countryside or except late in the night, but you drive in a crowd, in traffic. And as Peter Sloterdijk, the philosopher, would say, you drive in a foam which is an assemblage of monadic co-isolated entities. You also drive, or you can drive, with passengers, with human passengers, non-human passengers. So what I want to stress here is that there is a very important collective aspect of consent. You don't consent alone. I don't consent only by deliberating with me, myself, and I. And a lot of scholars already underline this social or collective aspect of consent, like Julie Cohen, for instance. So consent has a real collective dimension. It can have an impact on others, either your closest, your family, your friends on Facebook, for instance, or on society at large. Third point, and I will slowly conclude, you don't drive with full awareness. You don't drive fully aware of every single gesture you are doing. So you don't drive in a very rational way all the time. When I say rational, you don't drive, you don't outweigh the risk and the benefits all the time of your driving. So, and a third aspect also, you can get carried away. You can be distracted, bothered. And so what I want to say that consent is a bit like this. Consenting, you can be distracted when you consent, not totally aware of what you consent to. No, you can consent not totally rationally. And there is a very important aspect I want to underline here is the notion of routine or habit. And we should really investigate, when you talk about consent, this notion of routine and the dynamic between routine and consent, because routine is what helps us to avoid a perpetual renegotiation of the events, of the circumstances. Routine is happening at a pre-conscious level. Routine is embodied. It's made of perceptual hints, kinesthetic adjustments with the environment, with the car, with the body, and we can replicate this reflection when we talk about consent. So this was my third point. So 3 points: environments, the collective dimension, and the limited or the weakness of the cognitive capacity. And I will end with 4 remarks. So for all these reasons, because you consent in an environment, because you consent in relation to others, because you consent not always in a very rational way, it is a very complicated activity. It is not easy, and it can be even a risky activity, even dangerous. So for all those reasons, maybe, and I'm trying to push the metaphor and just to throw ideas on the table here, maybe we should impose, or we would need a driving license, a consenting license, a license to consent. Maybe we should also impose an insurance, a mandatory insurance, or at least to reflect about the distribution of risks. Third point, we should also be very careful and very aware of the fact that to consent, you have to be in a very intimate association with your prosthetic, with the digital device you are using. So you have to develop a familiarity with this device, and you can also be helped by devices to consent. Like you can be helped by device when you drive. I'm thinking, for instance, about the automatic system of speed, or about the seatbelt, this what I call the crying seatbelt, that always reminds you to fasten your seatbelt because it's yelling. So, and a last point, I want to insist on the fact that you need at one point to be able to stop your car, not to drive a car, but to bike, or to skate, or to take public transport. So I mean by that you have to withdraw even for a short time. And so there are different ways to consent, different means to consent, different transport to consent. I thank you very much.
Well, thanks a lot, Christophe. I think this is very stimulating, and I guess there will be some questions or remarks to start our day. No, and the other panel members maybe. Yes, Maurizio.
You said that the driving style is different in Naples and in Helsinki, but supposedly the rules should apply the same way in Naples and Helsinki. How would you say? How would you comment about this?
Yeah. This is a very good question.
To put it in another way, what is the role of the law in shaping also behaviors and the environment eventually?
I think that maybe we should reflect on cultural specificities, but especially on social specificities. And I would say that we have to take into account the social conventions more than the cultural convention, and the routine or the automatic consent that people give because they are part of a community, because all my friends consent to give away their data on Facebook, I do the same. So this is more important than I think that, yeah, law cannot tackle this, as such the cultural specificities when it comes to consent.
More, yes, Charles.
Thank you very much. I'm sorry about the disruption. Very interesting analogy. I think it was the case in Britain that when cars were first invented, they were required to go, well, they couldn't go very fast, but they were required to have somebody running in front of them with a red flag to warn horses and people and so on, which means that driving can kill. Have you explored the idea of whether consent can kill?
I wouldn't push it so far, but it can be a very risky behavior. And then we should also push the comparison, and we could make an analogy between physical integrity and informational integrity, but I don't think that consent can kill. Or maybe, yeah, maybe, I don't know. we should investigate. It's indeed a very good track to follow.
But surely that's why you need to be able to revoke consent.
To revoke?
Yes,
yeah,
and
yeah,
change your mind.
Mm-hmm.
Because if you find that what you've consented to is actually dangerous, as long as you're not physically impaired at that point.
Yes, I see a question.
Yes, I was quite interested by this notion of insurance with respect to the risk. And, but with respect to this, the risk must be clearly established, and in particular, when it comes to privacy, the risk needs to be established by the service provider also. It's something that needs to be explicit, and sometimes it comes to the notion of this relation between the fact to be consenting to something that is clearly expressed. And this risk has to be divided in the two parts. So do you have any idea about this, or?
No, I mean I totally agree with you in the sense that it's once again it's a collective or a multi-dimensional question. On one side, and we talked about that yesterday. Serge talked about with other people about impact assessment. So there is the problem of measuring or evaluating the risk caused by privacy breaches or infringements. And it's a very thorny topic, very difficult topic. On the other side, there is the problem of bounded rationality and how, as an individual, as a data subject, I evaluate the risk when I give away my data and in which situation, because this is all my talk about the environment is very important. You have to, of course, evaluate the risk according to a certain situation in a certain context. Risks are less important when you buy something on the internet than when you want to give away your genetic data. So in that case, the legislator, for instance, in Belgium forbids the possibility to give away the genetic data. So no consent is possible. So I was also mentioning the territories of consent. Like you have territories of where you can drive, you have to drive slowly, you can drive at full speed, or you cannot drive at all because it's a zone reserved to pedestrians. So,
okay, I think we will note here a very innovative proposition, I think, to start actuarial studies of consent. And I pass the word to the chair.
Thanks, Christophe, for this very inspiring talk. So our second speaker is Maurizio Borghi, Maurizio is a professor of law and director of CIPPM, which is a Center for Intellectual Property Policy and Management. So with Maurizio, we'll see the other side of the coin, the practical side, what happens in practice. Maurizio?
I'm afraid I will discuss some of the killing effects of consent, so to speak. I'm presenting some results of an empirical study we have conducted on a number of UK websites. I would not spend time in explaining what are the legal requirements for a valid consent under EU law, but we can just see some examples on how websites collect consent. Normally, the critical stage when websites collect consent is at the registration, so when someone submits personal data, name, address, etc. And in order to be able to use this data for purposes that exceed the delivery of the service, it is obvious that websites must collect consent. So here we have an example of a registration process where nowhere the website collects seeks consent from the data subject. And in this case, we can conclude that the website has no legal entitlement to process personal data for direct marketing purposes. Our focus now in my presentation is on consent for direct marketing, namely for sending emails and commercial information. Here, there is a sentence: by clicking register, you agree to the terms and conditions, and the terms and conditions specifies that the website will do a certain number of acts with the data subject's personal data, namely sending information, transferring data to third parties, etc. So here the consent is automatically signified by registration, and it has a broad scope. And we can safely conclude that this is an invalid consent under the current EU standards. Another very common practice is to seek consent with, by asking the data subject to tick in a box. Here we have an example where there is a box with an opt-out. So if you do not want your data to be processed, you have to tick the box. It is quite controversial whether this is a valid form of consent. We tend to think, and in the article we explain why, that this is not a valid form of consent under current EU standards. Here we have an example, finally, of a valid form of consent, a website that obtains a consent that is explicit, specific, and most importantly, freely given. So the consent must not be a condition to register to the service. Here it is separate, the consent separate from the registration, so you can register with or without consenting. The system is opt-in. You tick the box only if you want to receive emails. And the consent is not a condition, so if you do not tick the box, you can register in any case. There is another example which is similar, where there is an opt-in box, but the opt-in is pre-selected. So if you register and you do not pay attention to the consent box, you give your consent. We think that this is not a consent that is unambiguous according to the directive. So consent is specific but might not be explicit in this case. So our survey considered a sample of 200 most popular websites with the domain .co.uk. And on this website, we observed a number of features. We elaborated these features in order to draw conclusions on whether and to what extent websites obtain valid consent. To go to the consent point, we found that 69% of websites obtain specific consent, namely that they ask consent separately in the registration process. However, if we broke down this data, we found that there are a number of ways of collecting consent: opt-in, opt-out, and the pre-selected opt-in, so when the opt-in box is pre-selected. And we can conclude that it is only 16.2% of websites that obtain a consent that is unambiguous, freely given, specific, so that is valid under EU standards. We will draw some conclusions at the end on this. Then let me detail the second part of the test, where we wanted to test what is the behavior of the websites, whether they comply or not with the expression of consent of the data subject. So we created a subsample, and we created simulated identities, namely fake identities provided with valid mobile number, valid address, with credible personal data, and we registered to a sample of websites. We registered, for each website, we registered twice, once refusing consent, and the second registration expressing consent to receive emails, and then we made comparisons. So to explain, to give an overview of the operations performed on each website, the first simulated data subject refused consent to receive commercial emails. The second gave consent, and after 4 months, revoked consent, so opted out from receiving emails. So the red area represents the area where unsolicited commercial emails are received. The green area is the area of solicited emails. Essentially, at the end of 8 months, we counted the emails received in each email account. And I'm not detailing on the technical aspects of this, but this was in gross the result, that of course, when you give consent, there is a higher probability, 5 times more, to receive commercial emails than when you refuse consent. But still, when you refuse consent, the number is not 0 as it should be, but is nearly 1 email per month on average. And after revoking consent, again, the number should drop to 0, but still there is a good number of emails that are received after revoking consent. So, to break down a little bit this data, we have overall 1/3 of the website, 28%, that do not engage in direct marketing at all. So despite the fact that they collect consent from the data subject, they do not send any email. 72% do send email. Of this 72%, it is only 30% that respect consent. All other websites do not respect consent, either at the registration stage or at the stage of withdrawal of consent. To conclude, we have seen that the method of collecting consent is, we can divide the website into 4 big categories. There are websites that do not ask specific consent, others that do, with the opt-out, opt-in, or pre-selected opt-in methods. The method of obtaining consent is not a strong predictor of the way in which the websites behave. The opt-in websites have a better performance than opt-out, quite significantly better. Overall, 72% of the website sorry, this is the emailing activity, on whether the website will engage into sending emails. This is the slide that I wanted to comment, is the actual performance, the compliance. So it is 30% overall. And the websites that do not seek specific consent have the worst performance, so only 21%. And finally, the last data is some evidence, some data transfer. How do you collect this evidence? Well, simply checking the domain name of the emails that were received by each simulated identity. If the domain name is the same as the website, we can conclude that the website has not transferred data to third parties. When the domain name is different, then there is at least an indirect evidence that the data have been transferred. And we see that 67% of websites do transfer data to third parties. Incidentally, we have found that there are some recurrences in the domain names, namely that there are companies that collect data and send emails on behalf of the websites. Conclusion. The level of compliance with the data protection requirements is surprisingly low. We have seen only 16% of websites obtain valid consent. And this is surprising, also considering that we did not select randomly our website, but we selected the most popular, the biggest websites in the UK. So presumably the websites that are more likely to comply with data protection requirements. Few UK websites obtain valid consent, and this can also have a practical implication that what is the value of these data sets that are collected by websites? Also the commercial value of data that are not compliant with consent requirement. This might have a strong impact on the value of these silos of data. And since in the EU data protection reform, the notion of consent is going to become more detailed with also the inclusion of the explicit consent requirement, the question is whether UK online services are prepared for the EU data protection reform. The paper is published in the International Journal of Law and Information Technology. You can download it for free on SSRN, but don't tell this to the publisher. And that's it. Thank you.
Thank you very much, Maurizio. I think you raise a fundamental trust issue here. Maybe there's questions. Yes, can you bring the microphone there, please?
Thank you very much. It was a really useful study, and I personally will use a lot of data from the study. But regarding the conclusions you had, the first one, for me it's not surprising at all, having in mind the UK's requirements and the Information Commissioner's interpretations of the consent and opt-out being implicitly or explicitly accepted in the UK as a valid consent. So maybe if you ask these websites, they say we do comply. We have opinions and guidelines that would.
Yes, sure. In the article, we discussed the specificity of the UK and the fact that there is an infringement proceeding that has been withdrawn, but still it is a symptom of a bad implementation of data protection. So yes, UK is a specific case, and it would be interesting to compare this data with data from other countries.
Yes.
Yeah, another question from the UK perspective. This is very depressing, of course. What's even more depressing is the recent statement by our Information Commissioner that they're really only going to concentrate on what they consider to be serious infringements. Do you think anyone is going to consider consent infringements in this way serious enough to do anything about? I mean, I don't have any optimism of much change in the UK from this perspective.
Well, I don't know. It's not to me to assess this. What I can say is that the sending of emails is just a symptom of unlawful processing of data. Because if the website send unsolicited emails, we can presume that they use also data in other ways that simply cannot be discovered. So, if we consider that the data protection is a fundamental right, then yes, this could be a serious infringement.
More questions?
Hi, I have a question about, okay, so say you consent on them sharing your email and they send that to a third party. The moment you stop consenting, they still have that information and they can do whatever they like with it. They can share it with fourth parties, fifth parties, sixth parties, and so on. And there is an entire industry of organized crime that's circling around emails and having lists of emails, millions of emails to mass spam. It's been going on for the past 2 decades. So I think that's something I'd like to ask.
This is certainly, to me, this is a bug in the current consent system, because you cannot say that consent is revocable and then have no means of enforcing this towards third parties. Because if the consent is collected unlawfully in the first place, then all subsequent uses of consent are unlawful. But if the consent has been collected lawfully and then the data subject revokes consent, if in the meantime the data have been transferred to third parties, there is no means, there is no way to stop this use. I don't know if the regulation is addressing this point and to what extent this is addressed.
One more question? Okay.
Just to add something on the question and the answer here. Here, in such cases, erasure rights can be helpful, and with the new regulation, specifically when an individual revokes consent, the individual can request and can obtain erasure of information, and of the information in relation to which he revoked his consent. And after the LIBE amendments, also he can address such a claim against third parties to which the data controller has passed the information. So this supports the consent requirement, but yet again it's a matter of whether they will comply with such erasure requests. Thank you.
Thank you.
Thanks, Maurizio. Our next speaker is Roger Brownsword. Roger is a professor of law at King's College in London, and he was the founding director of TELOS, which is a research center on technology, ethics, law, and society. So maybe Roger is going to tell us how regulators can help in bridging this gap between theory and practice.
Okay, well, thanks very much, Daniel. I'm sorry, I've got quite a heavy cold, so I sound more northern than I usually do. But I'm going to try to think out of the box again and step back to a time when I was going to listen to one of Ronald Dworkin's lectures in University College London. Quite memorable because I saw Dworkin outside the lecture, actually on Gower Street outside University College, having a cigarette before he went in to give the lectures. One of the reasons it sticks in my mind. But I'm just wondering, in that part of London, Bloomsbury, which is still so Bentham in its architecture and characteristics, how Bentham and Dworkin, respectively, would respond to the question, why should anyone take consent seriously, or why should regulators take consent seriously? And a follow-up question, which is if they should take consent seriously, how should they do that? So those are the two focal questions for me in this 10 minutes. Why take consent seriously, and how should you take consent seriously? Well, I think once you've got a sense of how we should answer those questions, or how regulators should, then you can begin to see how they might map onto detailed regulatory regimes like the data protection regime. Okay, Bentham, I think Bentham's answer to that first question, well, my young man, what a strange question to be asking me. Why should anyone take seriously? You tell me, I really don't know. Because if you're trying to do the right thing, yeah, of course you should be trying to maximize welfare, minimize distress, maximize pleasure, or, you know, all that sort of thing. It's true, maybe in some contexts, people will be distressed if they're not asked. If they're not asked whether they do consent, there might be a sort of a certain politeness or etiquette there. And even a moralist might sometimes have to take account of that. But by and large, consent just isn't on the radar for us. Okay, what we're about is maximizing benefits, minimizing distress. Consent? No, you know, that's just not part of the game. For Dworkin, I think the answer would have been also very clear. And he'd say, why should you take consent seriously? He would say, if you take rights seriously, then you must take consent seriously. Okay? And that's where I want to start, really, with Dworkin's answer. Because if you were a regulator being pressed to defend why you were taking consent so seriously, whether in the context of data protection or any other kind of regulatory regime, I think the most obvious answer for you would be because it's part of a regime where we do take rights seriously. And of course, here we have potentially two fundamental rights that we recognize in Europe in play, privacy and data protection, both fundamental rights. Now, if someone, when they say this right is fundamental, isn't trying to signal to me that this is something we take really importantly, you know, why call it fundamental otherwise, then I don't know what they're trying to say. But if you do have a fundamental right in play, then I think the other side of that coin is that you have to take consent seriously. Because rights holders, when they are being asked to authorize acts which would otherwise be an infringement of their rights, whether it's privacy or the protection of their personal data, they're being asked to give up something that is part of a fundamental protection in their communities. They don't have to say yes. They don't have to say yes. But if they do say yes, it's very important they understand that they're giving up. It's like giving up a trump card in a game. You know, Dworkin talks about rights as trumps. They override routine political arguments. Okay? You are being asked to make a very important sacrifice when you're being asked to consent in relation to a fundamental right. Okay? So we should take consent seriously in those circumstances because it's part of that package. In other words, I'm saying that it would be illogical and incoherent for regulators on the one hand to say, here we have fundamental rights, but we don't have any particular interest in consent. My first and principal claim is that regulators who commit to fundamental rights also have to commit to consent. Now, you might think that a dreadful mistake has been made by regulators or by Europeans in saying that personal data protection is a subject matter of a fundamental right. But if that is the hypothesis, I mean, if that's where we start, that there is a fundamental right in play here, then I'm saying the only coherent thing to do is to take consent seriously as well. And in a minute, I'll explain why and how you take consent seriously. I don't want to maintain that the only circumstances in which you should take consent seriously is the one in which a fundamental right is engaged. I mean, that's the paradigmatic case, but I don't want to say that's the only case. Regulators might give you other reasons for taking consent seriously, even though no fundamental rights are engaged. And the most obvious, so obvious it's hardly, so self-evident, the most obvious reason for taking consent seriously is where the regulator's bottom line justification for some particular act or intervention is that they do this with your consent. That, in other words, when you're asked to justify why someone should act in a particular way, the bottom line reason you give is not that this is going to make the world a better place or anything like that. No, sort of Benthamite response or a communitarian response. The bottom line answer is you consented. I mean, if I were to say to you before I started this morning that we have to understand there are certain house rules in play here and you're free to leave if you don't like them. But look, I don't want anyone who's here today leaving this lecture theatre and saying and reporting what I've said in this presentation this morning. Okay, this is one of the terms and conditions of being present. It's not, but if I were to have said that, yeah, if I had said that, then suppose that in breach of that, you subsequently went off and reported what I'd said, and I engage you and say, look, hang on, what are you doing? Didn't we have an agreement? Didn't you consent? And you might say, yeah, but I think it was very important that people should know what you said, for one reason or another. I said, yes, but look, you consented. My only argument against you in the end is you consented. So if that's the setup, that the only reason you can justify holding someone to something is they consented, then you have to take consent seriously because that is your bottom line justification. Okay, and I don't want to say that exhausts the circumstances where we take consent seriously either, because I think in many cases where we're trying to track the autonomous decisions of agents, we also are very concerned to make sure that we've got it right in relation to their consenting intentions. I mean, I've been involved in a debate back home with arguments, long-running arguments about making it permissible to have assistance with suicide. And on both sides of this debate, there is great anxiety about consent. So, I mean, I think there are many contexts in which you should take consent seriously, but the two leading ones are where fundamental rights are in play and where your bottom line justification is that this person has consented. Now, the second question is how then do you take consent seriously? And the most obvious way is that you create a rather robust and precautionary set of conditions before you recognize that someone's given a valid consent. And there's a great deal of muddle and confusion here, I think. I mean, I would say that the principal conditions are that the rights holder, to take that case, has given a free consent, meaning it's an unforced choice, it's not coerced, it's not unduly incentivized, it's free, but that's a minefield of interpretive difficulties. It's free, it's informed. Huge amount of confusion, I think, about what counts as an informed choice. I know Jane's going to be addressing this, but I mean, I would say that the important thing in this context is that the rights holder understands that they are saying yes to an act that would infringe their fundamental rights, and what acts it is they are saying yes to, that they're authorizing these acts. Of course, thirdly, that the rights holder has the capacity to consent, and fourthly, that the consent is unequivocally signalled. So, it has to be free, it has to be informed, it has to be the right capacity, and it has to be unequivocally signalled. Now, when regulators start introducing requirements about explicitness or specificity or anything like that, it's very important that they align this with one of these conditions. Which one of these conditions, if any, is this applicable to? Because having consented, there will then be an interpretive question about how much you have actually consented to. What was the scope of your authorization? An interpretive question. And there are questions there about the breadth or narrowness or the explicitness of your consent. I mean, a lot of the questions there aren't about, I think, whether you've given a valid consent, but about the scope of the valid consent you've given. Of course, in the end, for the recipient of the consent, the bottom line is the same, that if you haven't given a valid consent and their act is not within the scope of your authorization, then they're in trouble. Okay, but there is conceptually a distinction between the set of conditions that apply before you can say, right, this has got over the threshold, this is a valid consent, and the actual terms and scope of your consent. They are different conditions. And these references to what's explicit or specific can get muddled up, I think, in relation to where we are on that. Now, the other point, and the final point I make is that the less obvious way in which you should take consent seriously, if it's a matter that you have to take consent seriously, is you are going to have to be very fussy indeed about the reasons that regulators will allow for persons to operate where fundamental rights are engaged without the consent of the right holder. Okay, in what circumstances can we justify going ahead, even though we don't have the consent of the rights holder, or maybe even in circumstances where the rights holder has said flatly no? In what circumstances can you justify going ahead? It's going to be a very restricted list indeed. The most obvious reason is that in a community of rights, you would say, well, there are other rights potentially in play, and sometimes we have to breach the right of one particular member of our community in order to serve a more important right of another member. I mean, if you're talking about breaching data protection rights or privacy rights in order to save the life of a member of the community, then you might say, well, that's, you know, it's unfortunate and it's regrettable, but all things considered, that's the best you can do. Or again, there might be catastrophe or emergency situations where the whole infrastructure or substratum on which your community rests is at risk, and where rights have to be breached in order to salvage that, because without the infrastructure being secure, then there can't be any kind of community, never mind a community of rights. So, but I mean, we can argue all day about exactly what should be on that list, and of course we know that in the Data Protection Directive and in the regulation, draft regulation, there is a list, and it's a list again like the conditions that apply to a valid consent. That's infinitely open to interpretation, but just what qualifies to get on that list is the question. If you are taking rights seriously and taking consent seriously, you're going to take a very conservative view about what's available on that list.
Thank you very much. Any questions? Yes, there's the first one. Microphone.
Thanks. So consent begins as unilateral speech act. But once there's another party there, it becomes bilateral, and the other party relies on my consent.
Yeah.
So it becomes a contract of some sort.
Right.
And once reliance comes into picture, it might affect revoking consent and the ability to revoke it. It might affect the right to erasure in some ways, because somebody has already relied on that. So basically the question is, what about the other side? What about the recipient and his or her or its fundamental, maybe, rights?
Well, thanks very much for that question. I mean, there's a whole area that I didn't have the chance schematically even to talk about, and that's the area where we shouldn't take consent too seriously, where we can take consent less seriously, where fundamental rights aren't engaged or regulators have other objectives that are served by the scheme. And I think your question makes perfectly good sense. Well, it makes sense in all zones, actually, but I'm particularly sympathetic to what you say once we move away from these hotspots, where we're taking a precautionary view that privileges the party giving the consent. You know, the thrust of your question is, what about the recipient of the consent? Absolutely right. Without reliance on consent, we're in real trouble. And so many routine transactions depend on this that we can't then be too fussy about making absolutely sure that this does reflect the will of the consenting party, ostensibly consenting party. And so, you know, I can imagine regulators in these zones where they don't need to take consent quite so seriously, saying, well, consent's implicit, or, you know, it's available by an opt-out, that's perfectly okay. And even if the subjective intention of the apparently consenting party was not to consent, they've given a signal that they didn't intend, but the reasonable recipient would think, oh, they are consenting, then maybe the regulators will say, well, that will do as a valid consent in these circumstances. But the bottom line justification in all these cases is not going to be this person consented. It's part of the package. I mean, in the panel that's coming up later on this morning, where we will be talking more, I think, about contractual kind of situations, You know, in the old world of contract law, going back into the 19th century, carriers were providing a very useful, cheap service, but they often had very high-risk packages to carry, which were stolen, and they took big losses, and they started introducing limiting notices. You know, just having notices on the premises saying that we don't accept liability beyond such and such, or you have to declare. And it was not clear that the clients, as it were, had really accepted those terms. They might not have really been aware of them. But as the 19th century played out in English common law, the courts got to a point where they said it doesn't actually matter whether the individual really understood this. The question is whether reasonable steps were taken by, in terms of the recipient, to inform a party about these terms and conditions. And yeah, I mean, I think that there's a trade-off here.
More questions? I see a hand there. While she's walking with the microphone, Roger, I was thinking there's no space for any form of paternalistic interventions of the state in your construction.
Well, I think the two short answers to that, Serge, I think that I'd want to develop. I mean, first of all, what about the people who don't have capacity and therefore are not players in relation to consent? I mean, where we make these so-called best interests or substituted judgments for people in situations where we'd normally want the parties to consent, then there might be, I think there's paternalism at play there. Isn't the best interest judgment I think the paternalism operates there. I mean, I know a lot of people take a very negative view about paternalism, and I think quite rightly where you're dealing with competent adults, you shouldn't be paternalistic, but where you're away from that, I think there is scope for paternalism. And I mean, the other way in which you might take a sort of paternalistic view is rather in this zone that we were just talking about here, that where maybe economic interests are at stake, and you would in an ideal world want people to consent, but you know there are a lot of vulnerable people out there who, if you rely on consent, will make decisions that go very badly for them. I know when I came here 3 or 4 years ago, I was in a very hard time indeed standing up for consent by people who thought that it was just too easy to get consent, and that your protective regulatory concerns weren't well served by that you needed another strategy. Like in consumer contracting, where you just say, well, look, these kind of terms are blacklisted. You try and impose this kind of term in a consumer contract, it won't be enforced. We're not going to let people sign up to a contract that says they take the risk of someone negligently causing them death or personal injury, that kind of thing.
Okay. The last question?
So I want to follow up on your last comment. Oh. So the structure you set in place was that if we have respect to rights, yeah, we should have respect to consent.
Yeah.
But my sense is that if we respect consent, we'll end up with disrespect to rights.
Okay.
Because we'll provide people with consent. The majority will still agree to privacy breaches. That will send out a normative signal that there's disrespect to a fundamental right. There's going to be very little that we could say about that because we're respecting consent, and that will water down not only a fundamental right of privacy, but possibly even a fundamental right in other aspects. So I'm not sure that Dworkin is doing the work for you that you wanted.
Yeah. Can I answer that one? Quick. Well, this is an echo of the conversations 3 or 4 years ago. And I hear what you're saying. I do take the point, but I mean, if I can go back to the example of euthanasia or assisted suicide, where we might think rights, fundamental rights, autonomy rights are at stake here, and yet paternalistically or protectively, we say because we can't be confident that people who agree to sign up for assisted suicide, they will not be allowed to do that. We're going to have a prohibition against this because we think this is actually in the best interest of these people. We can't be confident that the consents they give haven't been in some way incentivized, or that the distorted judgments they're making. And the examples I know that you have in mind are rather of a different order, that people will just click through or whatever. But and that the consents won't be reflective. But I do think that if you are signed up to rights, then there's a big sacrifice being made here in kind of departing from the script.
Thank you very much, Roger. Our last speaker is Jane Kaye. Jane is Director for Center of Law, Health and Emerging Technologies at Oxford. And Jay is going to talk about consent in the medical sector. Jane?
Thank you very much. Thank you firstly to the organisers for inviting me to speak, but most importantly to my panel, my fellow panel members who have actually provided a great foundation for what I'm going to talk about. And I'm going to talk about dynamic consent, which is an online communication interface that has been developed in the medical context, but I think it can be driven on different roads. So I think it is a concept and a tool that can be used in many different contexts. And the medical research context or the clinical context actually has given us a great way to test run some of the really kind of sensitive issues around the use of personal data. Now, there's a caveat here. I think this might be the wrong slide deck, but I'm going to move on. So what just the outline of this talk, I'm just going to talk very briefly about privacy, medical research, some of the challenges, patient and participant-centric initiatives, and then on to dynamic consent. So let's start with what is privacy. And we have this formulation of privacy from the Supreme Court of England. And basically, what this is doing is saying that privacy actually enables people to exercise their autonomy and to be master of all those facts about their own identity, the presumed owner, but this control can only be loosened, abrogated, if the state shows an objective justification for doing so. So very much along the lines that Roger was talking about. But I think this formulation is very much about control, and it has deep philosophical origins. But what it has meant in the medical context is that we start to have, when it starts to be implemented, we see a dance between consent and anonymization. And what happens is that you either have consent or you anonymize, which means you don't have consent. And I think this is really quite an unuseful way of going on. Thank you very much. So what I think is more important and what has come out of our focus groups is that people really think that that privacy and consent is more about a right to know, so the first data protection principle, rather than a right to control. So as lawyers, we're thinking about control, but in actual fact, patients and participants are thinking quite differently. But our starting point for dynamic consent was really thinking about control. So what's happening in medical research? This is an artist's impression of the internet, but it's also a very good demonstration of the networks that are happening in medical research, but also within clinical care. And what's important about these is that there have been electronic platforms developed for medical research in particular. And so we have bioinformatics infrastructure that enable people to look at specific genes, compare them with genes in knockout mice. But in terms of participants in research, it's all on a paper-based system. It's all paper-based consent, and thinking about how we can use IT to engage patients really hasn't been there. And as we move closer towards personalised medicine, I think there's more of an interest in this. So what's happened in medical research is the quantity of data has increased. It's more comprehensive because now we can move to whole genome sequencing, which is actually going to become routine in the clinic very quickly. And also there's far more genetic information revealed about the patient than with more targeted methods. And so genetic sequencing will become more cheaper and more commonplace, but also as we start to move to big data approaches, we're starting to use data that's coming in to the medical research context, which actually hasn't been generated in that context. So some of the challenges here are, is it about protecting identities, i.e. maintaining the confidentiality of data? And I think that's way that a lot of protections have been put in place, rather than enabling the control by individuals of the use of their data. So I think that quite often in medical research we talk about protecting privacy, but in actual fact all we're doing is protecting confidentiality of information through anonymization. So the move is to using large data sets of and pulling together profiles on individuals. So in this context where you're actually bringing together many sources of information, it's difficult to keep the identity of participants anonymous when data is shared, and particularly when it's shared across the world and placed in open access repositories. But not sharing also again is against current funders' policies and the specific need for large sample sizes. So you can distinguish individuals, and the Homer paper actually demonstrated that that you could do that using summary statistics. So I think in many ways we can see that actually genetic information, linking it with other information, means that you can identify people easily. So I think that we're moving to a point where actually anonymization is kind of a red herring, and it's a bit like putting a gate in a field. Because data is flowing and information is moving, in actual fact, putting in all these sort of safeguards about anonymization are actually ineffectual. And really what we need to be doing is going back to individuals and actually engaging them in the research process. But that actually means that you need to rethink governance. And I think that consent, although I'm focusing on consent, consent is part of a broader governance structure which has a number of mechanisms within it. So let's just think about consent. We go back to the point that broad consent, as we start to move to these infrastructures and flows of information, has become the norm. So people actually require a broad consent for many types of research uses, for actually putting personal data on an infrastructure so that it can flow around the world. And therefore, there's been a reliance on broad consent. But I think this is actually problematic. And some of the reasons why this is problematic is because that we know, everybody at this conference knows that we are seeing huge changes in the law, and we're actually seeing, in terms of medical research in particular, a different direction of travel. So it means that now we're seeing that there's the potential that explicit consent may be required for the use of identifiable information in research. If we can't anonymize, then we must obtain consent. So consent is the cornerstone and the best way for individuals to have control over data processing. But also it will be difficult to actually, the justifications of it, as Roger was pointing out, must really be there. So we need to have better procedures in place to enable people to give consent to, but also know how data is being used. So I think there are a growing field of participant-centric initiatives. So what are these? Basically, they put participants at the center of decision-making, but they're also about empowerment. And they, through the use of technology, they enable the communication and interactions over time. So it's very much about empowerment and partnerships. But as I said, this is a relatively new field. So Reg for All is a patient group in the US, and they have taken our concept of dynamic consent and are applying it to establish a patient registry. There's patients like me, Genimera, where you've actually got crowdsourcing for research, and Cure Together, which has actually now been bought by Google because it was such a great idea. And basically it enabled people to share their symptoms and the solutions to some of the physical conditions they were experiencing. So what's the dynamic consent model? Well, it's really an online interface that can be used on the web or on an app. And what it does is it actually enables people's preferences to be recorded and acted upon in real time through the use of what I'm calling, in a very generic sense, of sticky policies. So if I give consent to a certain type of use of my information, that will then travel with the information as it moves through networks. And therefore, if I change my preferences in real time, it will also be attached to the data so that whoever uses the data can actually know what the consent preferences are. It also allows many different kinds of consents to be selected within this online interface. So we're not just stuck with a broad consent for many uses of data, but the potential is that you can go back for very specific and explicit types of consent. It also enables vacation breaks. So this is part of an ongoing relationship with people, so that people can say, I do not want to be contacted during this period, my life has changed, I don't care what you do with my data. But if they come back after 5 years after having a child, maybe with a genetic disorder, and they do want to get involved in research, they can change those preferences. But also, it's using clips and a cascade of information, so this is very much tailored towards individuals. So what does it do? It places individuals at the centre of decision-making, enables ongoing communication and interaction, and we're testing this out for clinical care as well as for research, so that we start to bring those two domains together quite seamlessly. It puts a record of all consents and interactions in one place that can be easily accessed by the individual. I don't know about you, I have 1,001 passwords around the world, and I think there's really some work to be done on that, but also having all the things that I've consented to in one place would be very useful as well. And potentially, in this context, it can be part of a personalised medicine approach. So the thing about dynamic consent is, in a world where there are changing legal requirements, it ensures conformity with legal and ethical requirements, both nationally and globally. It can be used to streamline recruitment, consent and reconsent processes, as well as feeding back research findings. Recruitment costs are lower, greater accountability, and the accreditation could lead to fast tracking of decisions by research ethics committees. But what are the challenges of implementation? This requires a cultural reorientation. It requires medical professionals to actually deal with the blind spot that has existed regarding the involvement of patients and participants in research. It requires a move to partnerships, an understanding and valuing of the role that patients play in research, but also the superheroes, the healthy people who never make it into hospital or into the healthcare system. And it's the development of policies and practice to accompany it, as well as the investment or the reallocation, I would say, of resources. So, in conclusion, I think consent is one part of governance, and we need to have other forms of governance. Our focus groups have said that they think consent is really important. You cannot do away with consent. But what's happened, I think, in medical research is we've had a focus on consent, which means that we get into this dance about consent and anonymization, when actually what patients and research participants want is actually more information about research and how their information and samples are being used to help others. So dynamic consent, while it started for us very much as a consent kind of focus, is really a communication tool, and it's embedded in relationships, and it's about promoting trust. So it is part of an ongoing relationship as part of people's treatment and health care. But I think also it can be used in other contexts. So it can be used on other roads. And I would be really happy to talk to people about implementing this within healthcare, but also in other contexts. So thank you.
Okay, we have time for 2 questions. There is a hand there.
Yes, I'm quite curious to, it's a bit technical question, I'm sorry, but I'm quite curious to know what is the exact process of reformulating a consent. I mean, when people used to consent to a certain processing of their data, and suddenly they say, I don't want anymore my data to be processed this way. Do this reformulation of the consent affect the previous data that provided in the system? Or do you consider that this consent only affects the new data that will enter, that could have entered the system?
So that's a really important question. So as you know, that different data sets, if you have a data set that you're getting new versions of it all the time. So we work with different researchers to see what they're capable of. So the way we're formulating this is that it is very context-driven and what can be provided in that context. So for some researchers, if someone changes their consent, it applies to the new version of the data set. But in terms of revocation of consent, then actually what you're revoking to and making it more apparent is it will only apply to the new data coming in. So we cannot, once the data's gone out into a network or being used, you can't actually do that. But actually we're being honest about that. And I think people don't know that at the moment. But also this has the capacity to be more nuanced in terms of revocation. So instead of being part of a research project and just removing yourself from the whole process, the whole project, everything to do with it, the whole biobank, the whole infrastructure, in actual fact, you can be more nuanced and say, I just don't want my data and samples to be used for this research process. So it enables that granularity and enables people to really kind of exercise their autonomy, but also to be very explicit about how that's done.
I'm Haruo Takasaki from Japan KDDI telecom operator. We are also developing the privacy management platforms, reading the customer's preference on privacy and matching the privacy policy of service providers. So we dynamically treating the consent. Great. So what is your project is already installed, implemented in empirical research or empirical application or something like that?
Thank you very much. Basically, we have a prototype which will be operational in May, and that is working with clinicians who are working around rare diseases. And they do translational research, so they're clinically based but do research. So I would love to talk to you afterwards about your work. Thank you.
Thank you, Jane, and thanks to all our speakers. Thanks also to the audience for all your questions. I think it's time for the break.